Due process of law. The defendant must be given an opportunity to be heard. In the case of Belen versus Court of Appeals, the Supreme Court declared PDs 1670 and 1669 unconstitutional for violating the Due Process Clause because the decrees do not provide any form of hearing or procedure by which the petitioners can question the propriety of the expropriation or the reasonableness of the compensation to be paid for the property. Writ of possession. Writ of possession becomes ministerial upon 1. The filing of a complaint for expropriation sufficient in form and substance, and 2. Upon deposit made by the government of the amount equivalent to 15% of the fair market value of the property sought to be expropriated per current tax declaration. So if naani sila, it's ministerial upon the government to take possession. The issuance of the writ of possession becomes ministerial upon 1. Filing of the complaint for expropriation sufficient in form and substance, and 2. Upon deposit made by the government in the amount equivalent to 15% of the fair market value of the property sought to be expropriated. From the case of Biglang Awa versus Judge Pacalia, the determination of whether the taking of property is for a public purpose is not a condition precedent before the court may issue a writ of possession. Once the requisites mentioned above are established, the issuance of the writ becomes ministerial matter for the expropriation court. From the case of Francia Jr. versus Municipality of Mikawayan, 2008. A hearing will have to be held to determine whether or not the expropriator complied with the requirements of RA 7279. It is therefore premature for the Court of Appeals to insist on finding whether the respondent or the petitioner resorted to other modes of acquisition provided in RA 7279, and as this question will have to await the hearing of the complaint itself. City of Manila versus Serrano. This hearing, however, is not a hearing to determine if the writ of possession is to be issued, but whether there was compliance with the requirements for socialized housing. Once the two requisites above are complied with, then the writ of possession shall issue as a ministerial duty. So, ang writ of possession ma-issue as a ministerial duty of the expropriating court once mauna tong filing, makafile og ED complaint that is sufficient in form and substance plus ang 15% ma-deposit sa government, ang 15% sa amount sa expropriated property. Plaintiff's right to dismiss the complaint in eminent domain. In expropriation cases, there is no such thing as a plaintiff's right of matter to dismiss the complaint precisely because the landowner may have already suffered damages at the start of the taking. The plaintiff's right to dismiss the complaint has always been subject to the court's approval and to certain conditions. From the case of National Power Corporation versus Pobre and Pobre versus Court of Appeals, the right to repurchase or reacquire the property. In Mactan, Cebu International Airport Authority versus Court of Appeals, it was held that the property owner's right to repurchase the property depends upon the character of the title acquired by the expropriator. That is, if the land is expropriated for a particular purpose, with the condition that when the purpose is ended or abandoned, the property shall revert to the former owner. When the former owner can reacquire, the judgment in the expropriation case were very clear and unequivocal, granting title to the lot in fee simple to the Republic. No condition on the right to repurchase was imposed. In arguing for the return of the property on the basis of non-payment, respondents ignored the fact that the right of the expropriatory authority is different from that of an unpaid seller in ordinary sales, to which the remedy of rescission may perhaps apply. Expropriation is an in rem proceeding, and after condemnation, the paramount title is in the public under a new and independent title. The case of Court of Appeals versus Republic versus Court of Appeals 2002. Expropriation under Section 18, Article 12. The state may, in the interest of national welfare and defense, establish and operate vital industries upon payment of just compensation, transfer to public ownership utilities and other private entities to be operated by the government. So how is this different from Section 17, Article 12? Ang Section 17, Article 12 states that in times of national emergency, When the public interest so requires, the state may, during the emergency and under reasonable terms prescribed by it, temporarily take over the direct operation of any privately owned public utility or business affected with public interest. In the case of Agan Jr. versus Philippine International Air Terminals, Batirina versus Philippine International Air Terminals, and Lopez versus Philippine International Air Terminals, the Supreme Court said that PIATCO cannot, by mere contractual stipulation, contravene this constitutional provision and obligate the government to pay reasonable cost for the use of the terminal and or terminal complex. The constitutional provision envisions a situation where the exigencies of the times necessitate the government to temporarily take over or direct the operation of any privately owned public utility or business affected with public interest. It is the welfare and interest of the public which is the paramount consideration in determining whether or not to temporarily take over the particular business. Clearly, the state, in effecting the temporary takeover, is exercising its police power. Note that the temporary takeover by the government extends only to the operation of the business and not to the ownership thereof. As such, the government is not required to compensate the private entity owner of the said business, as there is no transfer of ownership, whether permanent or temporary. The private entity owner affected by the temporary takeover cannot likewise claim just compensation for the use of said business and its properties, as temporary takeover by the government is in the exercise of police power and not the power of eminent domain. The case of Agan versus Piatco. In David versus Macapagal Arroyo, the court declared that Section 17, Article 12 must be understood as an aspect of emergency powers clause. The taking over of the private businesses affected by public interest is just another facet of the emergency powers generally reposed in the Congress. Thus, when Section 17, Article 12 provides that the state may, during emergency and under reasonable terms and conditions prescribed by it, temporarily take over or direct the operation of any privately owned public utility or business affected with public interest, it refers to Congress and not the President. Whether the President may exercise such power is independent on whether the Congress delegates it to the former pursuant to a law prescribing the reasonable terms thereof. Expropriation under Sections 4 and 9 of Article 13. Comprehensive Agrarian Reform Law. In Association of Small Landowners versus Secretary of Agrarian Reform on the constitutionality of the Comprehensive Agrarian Reform Law being an exercise of the police power of the state using eminent domain as an instrument to accomplish police power. In Santa Rosa Realty Development Corporation versus Court of Appeals, it was held to the extent that the CARL prescribes retention limits to the landowners, there is an exercise of police power for the regulation of private property in accordance with the Constitution. But where to carry out such regulation, the owners are deprived of lands they own in excess of the maximum area allowed. There is also taking under the power of eminent domain. The taking contemplated is not a mere limitation to the use of the land, but the surrender of the title to and physical possession of the excess and all beneficial rights accruing to the owner in favor of the beneficiary.